Welcome again to the Melling Law YouTube channel, where we have different estate planning topics relevant to people living here in Utah. Today we're continuing the series about making a bulletproof estate plan. How can you plan to make sure your family is protected and that your wishes are actually honored? It's one thing for an estate plan, whether it's a will or a trust or a combination, to say something. It's another to actually have that count when it matters, whether it's because of the way the law will work or the asset structure. And one of the more complicated ones is our topic today, which is the step family situation. If you have a step family, the state law really does not usually work as intended. So, and there are a lot of provisions in the law that even if we say something, that's not necessarily what's going to happen. So this is where you definitely want a professional's help. For example, if you've remarried but you have children from a prior marriage and you've been married for years and years but kept everything separate as far as banking goes, there's a good chance that even if you leave everything you own to your children from the previous marriage, that your spouse is still entitled to a good chunk of your estate, depending on how the estate is treated, up to a half or a third, depending. Once again, the calculations do get complex, but between about a third and a half of the estate could be up for grabs. Even though you leave it all to your children, it could need to go to your spouse. And let's say hypothetically, your spouse is really, they want everything to go to your children too, but they've become incapacitated and they have someone managing their affairs on their behalf at the time you've passed away. If that's the case, then that person could even be duty bound to sue for that elective share. So even though your spouse was on board with the plan, your children were on board with the plan, it could end up that person that's caring for your loved one and their finances has to sue your estate to get to whatever they're entitled to under the spousal elective share or an intestate share, depending on how the estate plan works. So that estate plan needs to be ironclad. It needs to be done in a professional way and account for those family dynamics. One of the good ways to plan for that is a prenuptial agreement, but there are other ways around that if you're already married and just now getting around to doing your estate plan. So if you have a step family and you want to make sure your estate plan is bulletproof, make sure you get it done. Make sure that your estate is done by a professional that specializes in estate planning. If you ever have questions, you can reach us at 435-572-0807.